Uh, The date of the judgment of the case is 17 April 1913. Plaintiff is Lalman Shukla. The defendant is Gauri Dutt. The court is decided. The case is High Court of Allahabad. The bench is Justice Banerjee. Introduction. The case deals with the concept of validity of the contract. The case also deals with the communication of proposal. It is landmark judgment decided by the Allahabad High Court. Fact of the case, the defendant Gauri Dutt was the owner of the firm and the plaintiff Lalman Shukla was the munim of the firm. In this case, the defendant nephew was absconded and was nowhere found. The defendant has sent his servant to find his nephew. The plaintiff Lalman Shukla was one of those servants who were sent to Haridwar to find the nephew of the defendant. The defendant gave some money to the plaintiff for his railway fare and other expenses. While the defendant's servant were looking for his nephew, the defendant issues a handbill claiming that if anyone found his nephew and brought him back, then he would be rewarded with rupees 501. The plaintiff, who was the servant of the defendant, found his nephew and brought him back to his home in Kanpur. 6 months after the said incident occurred, Gauri Dutt asked the plaintiff, after removing from the job, the plaintiff claimed the reward of rupees 500 from the plaintiff and filed the case against Gauri Dutt, his master, for not rewarding him as he was entitled to. Issue raised: nature and clarity of the offer made by the defendant regarding the reward, determination of whether a valid contract existed between the parties, whether the plaintiff is entitled to get the reward from the defendant, and whether is there any valid acceptance given by the plaintiff to the defendant. Judgment. The High Court of Allahabad observed that the acceptance of the offer as claimed to be fulfilled by the plaintiff was not a complete one because the plaintiff had no information about the handbill. For the acceptance of an offer, knowledge of the offer is essential. The handbill were advertised after the plaintiff went tracing the defendant's nephew in Haridwar. The act of the plaintiff to search for the defendant nephew was not because of the reward offered in the handbill, but because it was his duty to search for him. He already had a subsisting employee obligation to be fulfilled. The act that the plaintiff performed was a part of the employment and not a part of the agreement for reward. There was no consideration on behalf of the plaintiff for which he can claim the defendant's reward. There was no fresh benefit for the defendant. No doubt the case cited by the plaintiff supported their contention, but their judgment have been criticized. Thank you. The last part is the conclusion part. The journal offer are the ones that are made to the public in general and not to any particular person. The judgment was indeed a celebrated one because it clarified what is an acceptance under the general offer which are expressed one. It has clarified the stance that journal offer can only be accepted when there is a knowledge about the offer. The case Lalman Shukla versus Gauri Dutt 1913 touched upon the basic concept of contract, the vital element that form an agreement, offer and acceptance. Thank you.